fine with percentages as long as they are based on accurate data that can be verified in the marketplace. If this is not difficult, then why hasn't it been done? It seems to me that we put the burden of proof on the taxpayer. They tell us in many cases they can't do it. But let me just give you 3 cases real quickly. 3 real cases in Santa Clara County. Case number 1, the Assessment Appeals Board found, and these are all with major corporations, the Assessment Appeals Board found no credible evidence that would prove that there was non-assessable software in that machine. They denied it. The Assessment Appeals Board in case number 2 found credible evidence because the company provided us with that data, and they granted the exemption. Case number 3, the company provided the assessor with credible, detailed cost information sufficient to verify, and we allowed the exemption. So all of those three things happened, and all I'm saying is if you provide us with the data, as in case number 2 or number 3, we will grant the exemption. But we can't do it by just saying 10% on this equipment and 23% on that without the relative data that can be verifiable.
Okay, Mr. Bernard.
Just real quick, again, same as the previous conversation, what's the real question here? And in my opinion, the real question is, does the 1972 law make sense? What we're talking about coming up with tables and exempting this, that is, in my opinion, bandaging up something that doesn't make sense today. Embedded software is everywhere. Your cell phone doesn't have it in it, it's actually going to be toxic waste. Your cell phone will be toxic waste. My wheelchair, no embedded software, it's junk. It's not worth anything. We have a job to assess property at its market value. That's if it's an integral part of the machine, it just makes sense that it is accessible. I think we need to look back at the 1972 law. This is coming from someone who, and many of you know me in my previous life, a pretty conservative, anti-tax person. And when Larry Stone and I agree on something, all right, it's scary, but it means it's probably correct. I think we need to really look at the 1972 law and make some sense of it, because what was applicable in 72 sure is not applicable today. The last case in point, we were all supposed to come in a bus this morning. The lift broke down, and I will guarantee you that it was because of the software that's in that lift that was a problem. So, and I noticed that these steps aren't working again, and it's probably the software that's embedded in the mechanism. But the point is, you can't get away from it. It's in everything. It's in that camera that's taking the pictures. The value of the machinery is, without the software, is nil or salvageable.
Okay.
The other choice you could have, go to the legislature and let's just exempt personal property. How do you like that? I'd go with that too. But either clarify the 72 law, get rid of personal property. Trying to bandage it up, in my opinion, is just making a bad law
Okay, Member Yi.
worse.
Thank you, Senator Renner. Let me just start out with a statement first. I agree with Assessor Stone that we require certainty. I would argue that certainty really resides with both the assessor and the taxpayer. So with that goal in mind, I would agree with Mr. Bordonaro in terms of the 72 statute. That has to be addressed, just straight up. Obviously, it's inapplicable, not necessarily relevant today. I also think that the likelihood of getting a proposal like AB 832 enacted is difficult. But I want to go back to a couple of suggestions that several of the speakers have spoken to, and that is the role of the board in this particular matter. And I would be interested to know from the speakers whether there is a role for the board to look at being the party that gets the data, obtains the data, and begins to put together some percentages that aren't arbitrary. And I know it means looking at lots of different types of equipment, but it at least would engage the parties on both sides. We would look for the most credible data that is out there. And we've done this in other areas with respect to valuation lifing studies. And what is wrong with that process? That's, I guess, my
Go ahead
question.
and have somebody go ahead and respond.
I personally don't see anything wrong with it. I believe that's absolutely in the purview and responsibility of your board. I view that as something of a big picture policy bandage, but it does have its usefulness.
And it's not to say that takes the place of the statute. I think we still need to tackle the statute head-on, but at least for practical, assessment practice purposes or evaluation.
Go ahead, Joe.
The reality is, the law is cardinal, and the law says that application software is not subject to tax. The only issue, until it gets overturned, whether it's a good policy decision or not, to do away with 995, the only issue is, how do we value that application software? You have a very expert property tax department that has been doing this for at least 20 to 25 years now, and this is particularly well suited for that expertise. And I would strongly encourage the board to take the leadership and to do it.
Yeah, and I'm just saying we have to tackle the statute because there's a huge gap between 1972 and Cardinal, so that's.
I'm gonna ask us now to go ahead and let the public come on up and make their comment, if you will. Same as before. Name, who you represent, and a brief comment.
Dave Dorr, representing Caltax. Feel I must come talk about this because I did the staff work on the 1972 bill, was carried by my boss, Joe Gonzalez, and I think there's some misunderstandings here. I do agree that there's a significant problem in terms of the identification, segregation, and the board has an important role. That's one of the reasons the board exists, for uniformity property tax procedures, so we agree with that. But the 72 bill at the time was trying to deal with the separation out of intangible values. We weren't, and the Constitution doesn't provide for assessing intangibles. We're trying to separate intangible values, and that's the reason, the whole thrust of the 1972 bill. And that, in context, it came after the problem of assessing movie films, where that you had a film that had a certain value, but most of that was felt to be intangible. The film itself didn't have the value, it was intangible values. And then we went on to other kinds of records, such as business records, that were thought to be intangible. The paper, it's on a piece of paper, that's tangible. But the feeling that the work on that, putting it there, represented the intangible values. Same with architects' drawings and things like that. So the issue wasn't trying to benefit some industry or this or that. It was dealing with intangible property. And the other issue, we're talking about constitutional problems. One, it's intangible. Two, personal property does not have the same constitutional protection as real property. The legislature can change it or do away with it. So it's not a constitutional issue.
Okay, thank you, Mr. Dorr. Come on up. And other speakers? One other one? Come on up, please.
Jason Chow with Ernst & Young. There are methodologies that have been used to quantify software. These have been done for financial reporting purposes, for tax purposes, for accounting purposes. Here there's techniques that have been used to quantify, whether it's an intangible or a software, component. And I think here, when these methods then were developed, it was sort of like what, you were saying before, is that it's not easy. The data is not readily available, but it was done. And, these methodologies have been accepted by, the tax authorities, whether it's income tax or federal tax, or even from the accounting regulatory bodies. So there is a way that to measure it. It's been done in other venues. So perhaps here, there could be a way to develop a process.
Okay, thank you. Thank you.
I believe you're correct. I think that companies do not just pull the cost of this stuff out of the air. Many have cost accountants that do nothing but monitor and control the costs that go into manufacturing any one of their products, labor costs, material costs, overhead, and all that kind of stuff. The companies that do are the ones that get the exemption for either from the Assessment Appeals Board or from my staff. Those that don't.
Okay, I'm going to bring us to conclusion and thank the panelists at this point. Also want to thank the Assessors Association for participating and I guess responding to our summons. Is that what we did to them? Yeah. And appreciate that greatly. I want to especially thank to our folks that were key to helping us put to this together, David Gow and Dean Kinney, and helping us to lead this process. At this point, I think what we want to do is I'm going to turn this back over to the chair, because I think one of the issues that came up in this discussion is, what is our role? Where do we want to go from there? And I think we want to have a brief discussion in regards to maybe what we have gleaned from this and where we need to respond to and opportunities that we have before us based upon the discussion that we had. So, Mr. Chair.
Okay. Thank you very much, Mr. Runner, for your leadership in conducting the hearing. It's very informative, very stimulating in thought as well. Obviously, there are some very complex issues, but not really all that complex when you look at the reality that the world has changed. And the world has changed significantly from a scientific perspective, from an academic perspective, and the things that we've done over the last 50 years just won't suffice in the next 50 years as we move forward in trying to address these issues from a governing perspective, from a taxation and evaluating whether it's fairness in taxation, establishing values, defining what is and what's not. So we have some real challenges here, but these are challenges that we can meet. I mean, we have the intellectual capacity to do this, working with the assessors and the Board of Equalization. We have the intellectual capacity to meet these challenges, and I certainly welcome an opportunity to do that. We're going to ask for closing remarks from Member Yee and the rest of our members. Did I catch you off, Bart? Okay.
I'm happy to.
In such cases, we'll go to the assessors. I'm okay catching you off guard.
I can speak.
Are you ready?
Yeah.
Okay. Member Yee, my apologies.
Thank you. Sorry. Thank you, Mr. Chairman. I wanted to offer some thoughts on both issues, and thank you, Senator Runner, for moderating two very stimulating panels. With respect to the first panel on split roll, I really hope we're not back here in 2 years, kind of we're in the same place. And I would like to advance the examination of the issue in this regard. I really don't think, and today may be the beginning of, I hope, an ongoing public discourse about the issue, but I really don't think it serves any party, any purpose, if it's not an informed public discourse. And I really want to figure out how to get our arms around the conflict that exists among the data and among the studies that have been put forth on split roll. I think the public discourse really ought to be, or the informed public discourse should start with not even an identification of a problem, because that automatically becomes a political discussion, but really, what's the lay of the land? What's happened since 1978? And as we have competing studies that suggest that certain types of property have been treated more advantageously than others, I would like to have some neutral third party, and I really am looking at our own Research and Statistics Division to essentially do kind of a fact check with all of the data that's out there and all the studies that are out there. It's a tall order, and it does become easily politicized, but I really do not want it to be politicized. We as a board, and we in partnership with the county assessors, we have a responsibility in administering this property tax system. And as outside parties have some desire to move with any type of a split roll proposal, I want to be able to speak with at least some level of credibility about what those proposals may mean. And so I think the next step is really trying to resolve some of the conflicts that are out there among the studies and the data in some formalized way. Maybe I'll leave it to that, and I'll speak on the second issue when it's time.
Thank you, Member Yee. Ms. Mandel? Mr. Bogdanario?
All I'm going to say is thank you for the opportunity. And I also want to thank Doug for leaving me these issues to deal with next year. Appreciate that a lot. You're welcome. And for the association for putting me in the position where we need to deal with these issues in this next year. It's going to be challenging, but again, I think if we could all get out and sit down at the table, be realistic, and get what the facts are, whether it is in the embedded software issue or the split roll, and be reasonable, then I think that we can together find solutions to these and other problems. Thank you.
Doug?
I'd like to also echo some of Tom's remarks in that. First of all, I want to thank the board and members of the panels for the discussions we've had today. We have some issues we need to get resolved, and I think the only way we're going to get them resolved is through what we're starting and what we've done today. And hopefully this coming year we'll make some progress. So again, I just want to thank everybody that did participate, as well as our people out in the audience. I think it's important that we address these issues. Move forward. Thank you.
Thank you very much. Mr. Runner.
Just a couple of comments on, and to make it on both the topics. The first would be, yeah, I would agree with Member Yee in terms of, I think a good role for us to have would be to step back, have our folks take a look at reviewing, doing some look at the various studies, the issues, the assumptions that have been made in regards to some of the conflicts and issues in regards to split role. I think that would be good data for us to have. And I think that we've got the ability and capacity to at least blend that and bring that together. I think that's a good issue. I also believe that probably in regards to the embedded software, it could be time for us to take a look at how it is that we can bring together interested parties to determine if there's a path to find solution. I think we've talked about some of the options here. I'm trying to get my arms around the concept of percentages on industries that go from, A to Z. But I guess we ought to find out if there's a path there. And certainly I think that's a way to help solve the problem that seems to be right now not solvable, and that may be a path to help get us there. So I think we ought to take a look at maybe looking at bringing this back, maybe as a future discussion for us in regards to how it is that we may want to look at looking at the process of percentages, some aspect of that.
Okay. Member Yee.
Thank you. I agree with Senator Runner. I was going to even take it a step further to see if the Property Tax Committee staff could convene just a discussion session.
We certainly would
Yeah.
be.
Okay.
We could initiate that.
Yeah, I mean, I really do think that, rather than have this continue to be fought, through the legislature where we're kind of looking at perhaps the assessors and the industry having to take some very hard positions. I think there's a role for this board to play to bring people together.
The
So,
legislative path is
yeah.
fraught with so many
yeah,
challenges.
and I was particularly intrigued by the gentleman that came up from Ernst & Young with respect to, how some of this information and data is available for financial accounting purposes. So to the extent that it's available for that purpose, how does that translate for tax assessment purposes?
Members, let me suggest that it be a joint effort of the Business Tax Committee as well as Property Tax, along the lines of trying to come up with a methodology and a technique as it relates to assessing the embedded software. I don't know if there are standards or if there is a way of coming up with a table that's going to be applicable to everyone. But I certainly believe that there is a methodology, that we can come up with a method, we can come up with a technique which can be employed in every situation, given that the data is there. Even if the default is to say that there is no exemption until the data is provided, that's certainly a reasonable approach as well. And so I think we can entertain that from the board's perspective. So let us take that under consideration. And in closing, let me thank all of you individually and collectively for sharing with us a moment in time. We won't get this moment in time back again, but certainly we'll have an opportunity to revisit the issues. Thank you so very much, and enjoy the rest of your day. The board is hereby adjourned.